Hello, I'm Peter Afrasiabi, a partner with the law firm of One LLP, and I'm the host of the Curious Lawyer series. This is a fun, whimsical series dedicated to going down the unbeaten paths that maybe you haven't been down before in terms of the law. Things like space law, dog law, even CIA law. We've covered presidential pardon law, and all sorts of fun, arcane areas of the law when you just want to have some light, interesting, and refreshing, indeed it is, refreshing CLE. It's not the difficult stuff of ethics, nor is it necessarily the technical, difficult areas of law that you practice in. This is when you just want to have a light, fun experience learning about something new in a different area of law. And today's presentation is on sex law. We are going to be looking today at how the legal regime regulates human sexual behavior and human sexual expressive conduct in terms of films, movies, and the like. So if we take a look at our first slide, you can see that what we're talking about here is the regulation of human sexual behavior by our legal system in terms of sexual conduct and the viewing or recording of sexual conduct. As we walk down this path, we're going to look at both federal and state laws that relate both to sexual behavior and prescriptions in terms of what sexual behavior is permitted and what is not, and also the actual filming, viewing, and possession of different kinds of sexual films and media that contain sexual images. This, of course, touches upon criminal legal regimes, and also we will look at civil legal regimes that touch on this area of law. And as we drill down a little deeper and look at the legal regulation, we're going to see and address topics such as statutory rape, incest, prostitution, adultery. We're going to cover copyright law in terms of obscenity and copyright law and the history of it and how it works today. And we're also going to look at trademark law and how trademark law also touches on sexual marks, federal registration marks, and sexual mores. And we will take a wander down peak laws, such as those laws dealing with zoom lenses and peeping toms. We will culminate with, as we often do in this Curious Lawyer series, with urban myths, urban legends in terms of the law. And here we're going to actually look at not so much urban myths and urban legends, but we're going to look at crazy, weird sex laws that are still on the books that you absolutely won't believe. So stay tuned for the end because we're going to get to some fun stuff. So if we get started now, we're going to start with statutory rape. And you can see on this next slide that what we're talking about fundamentally here is the age of consent and the legal systems and the state, specifically the state police power, but the legal system's regulation of what is the appropriate age at which one may consent to engage in sexual behavior. And if we take a step back a little bit, we can look historically at these statutory rape laws. They actually go back nearly a millennia to medieval England, where in the 1200s, there were punishments prescribed by law of 2 years imprisonment if one, quote, ravished a maiden within age, end quote. And that comes from the ancient code books from medieval England. And by the way, then the within age was less than 12. Very, very different, of course, to the modern world. If we look at the modern world, we can go straight to California Penal Code 261.5, and this is a pretty prototypical penal code section across the country in terms of all jurisdictions having prescriptions and provisions like this. We'll use California just as a prototypical example. And California makes clear that statutory rape occurs when any person engages in sexual intercourse with a person under the age of 18. Now, this specific statutory rape provision does not include oral sex, and nor does it include foreplay behavior. Now, there certainly are other criminal provisions in the California Penal Code that prohibit oral sex with minors, but it's not within the statutory rape legal regime, statutory framework. And so basically what this means is in California, those individuals who are 17 or younger are actually not legally capable of consenting to sexual intercourse and that kind of sexual activity. This then raises the question, and I'm sure many of you have been at cocktail parties where non-lawyers ask you about, hey, I've got a kid in high school and the kid's got a boyfriend or a girlfriend and I think they're doing something, what could happen? those types of questions about statutory rape. And so the important point to understand here is, what are the defenses to statutory rape? Well, consent is not a defense. And that is because the substantive nature of the crime and the legal regime in terms of what it's regulating posits that those under the age of 17 lack the capacity to consent. So it is not a defense to say, I'm 19, she was 17, she consented. No defense at all. Now, in California, there is the defense of a good faith belief that the person was 18 years or older. And that can be a defense in California, depending upon the age of the perpetrator, that is also. But it's not true in every statutory rape state. And if you want to see the prototypical type case in terms of a good faith belief, you can look at People versus Hernandez at 393 P. 2nd, 673. That's a 1964 case, but it's the pretty prototypical case in terms of addressing and defining the contours of this right to have a defense based upon a good faith belief in terms of the mistake of age. If we turn to the next slide, you can see we have a map of the United States, and this shows the age of consent across all states in the United States, and this is from 2016 data. But it's really a very, very interesting map if you spend a couple of minutes and just look at it and think about the map in terms of the ages on the map and where they are in terms of the United States. And so what's particularly interesting, I think, is if you look at the Northeast, it's all 16 years old and some 17. And that's true as you come down really the Atlantic seaboard with one exception, and it stays 16 into the South. But Florida is one notable exception requiring 18. And if you flip to the West Coast, you see California also is an 18 years of age of consent state. But you also then have down from starting in the Southwest and really just going all the way up to North Dakota, this sort of strip of states that are also, like California and Florida, requiring 18. We have New Mexico, Utah, North Dakota, and the like. It's really a very interesting map because I think it gives a lot of insight into how the different regions in the United States perceive what is the appropriate age of consent in terms of their local jurisdictions for purposes of regulation. And there is certainly some commonality that crosses state lines in terms of just these regional differences that you can discern looking at the map. Now, let's get to the next question, and that is, what if both people are under the age of 18? Well, in California, under Penal Code 261.5, it is still a crime and both are in violation of the statute. So it's no defense to say, I'm 17, she's 17, therefore we're okay. Both are technically in violation of Penal Code 261.5. Now, what's particularly fascinating is you look through the case law, and if you speak to your local criminal defense attorneys, you find and learn that there's scant cases dealing with kind of Romeo and Juliet lovers in high school being prosecuted. These are very rarely prosecuted, and so much of this hinges upon prosecutorial discretion in terms of whether to charge or not charge this type of conduct depending upon the local city, county, jurisdiction. But nonetheless, it is the law, and that is the letter of the law. Now, I mentioned Romeo and Juliet. I said that for a reason. If we see on the next slide here that there are actually in many, many states what are known as Romeo and Juliet laws. And as you see on this slide, Romeo and Juliet laws are targeted towards teenagers and young adults who may engage in sexual intercourse with someone under the age of consent. And we're going to use Texas as a prototypical example. And if you go back a couple slides, you'll see that in Texas, the age of consent is 17. And so these laws focus on people who may have sex or sexual intercourse with someone under the age of consent, but where they are still very, very close in age to the sexual partner. And what these Romeo and Juliet laws posit is that in such scenarios, these what would otherwise be offenders of statutory rape laws actually are not engaged in statutory rape and do not get classified as sex offenders. And so we can see on the next bullet point, if we look at Texas law states that if a person over the age of 17 has consensual sexual intercourse with someone under the age of 17, but where there's no more than a 3-year difference in age between the partners, then the Texas Romeo and Juliet legal regime springs into effect, and the older person will not be charged with statutory rape and will not have to register as a sex offender. And so that's a pretty common example of a Romeo and Juliet law. Now, practice pointer that's very, very important when you're at that cocktail party and you're getting a question and you're going to go and say, oh, don't worry, we have Romeo and Juliet laws. You need to know they're not in every jurisdiction, and there are some notable exceptions, such as California and Michigan, that do not have these Romeo and Juliet laws. So for those of you in California, Michigan, and other states, check carefully before you answer that question at the cocktail party in terms of what your friends, students in high school may be doing or not doing in terms of the legality of the law. But be aware of those Romeo and Juliet laws. Now, we're going to move from statutory rape to incest. And the legality of incest actually varies by jurisdiction. It's not illegal in all 50 states, although in almost every state it has been prescribed by positive law, that is, the enactment of statutes by the state legislatures. And so again, sticking with California, we will look at a typical code. And in California, we have Penal Code, California Penal Code, Section 285. And Section 285 makes it a felony to engage in incest. And incest is sexual relations or marriage between close relatives. The $64,000 question, of course, is what is the range in terms of how close a relative must be or must not be in order for one to be engaged in illegal incestuous behavior? And the definition from the California Penal Code essentially is relations by blood or half-blood. And so what you can see is that prescribed classes of people who may not engage in sexual conduct or marriage involve parents and children, grandparents and grandchildren, or anyone else with an ancestor-descendant relationship, such as great-grandparents and their great-grandchildren, for example. Siblings are also within the definition of prescribed classes. Half-siblings, the same. And then uncles and aunts and nieces and nephews, also within the class of relatives who may not have sexual relations together, lest they trip the incest laws. The next slide gets at the question of incest and what if you have consenting adults? And they say, we're consenting, we are completely aware of the prohibition on incest in terms of the risks and the danger, for example, with offspring, but we're consenting adults, and don't we have a constitutional right to engage in this kind of behavior? California has answered, no, you do not. And a prototypical case from California, but it's not that different to holdings in other jurisdictions you'll find. In California, we have People versus McEvoy. It's reported at 154, Cal Reporter 914, and this is from 2013. And in that case, what we confronted was a defendant being charged with a whole panoply of crimes, including incest. And the defendant claimed that the sexual encounter between himself and his sister was actually consensual. Now, that was a disputed fact issue, but that was the defense's claim, is that this was consensual. And the defendant argued that if indeed it was proven to be consensual, well then consensual sexual activity, even if between siblings, should be protected as a liberty interest within the 14th Amendment. And so the argument as it was mounted is that the state penal code, as it's written, falls under the 14th Amendment because I have a liberty interest in being able to engage in this type of sexual conduct or sexual behavior if it's with a consenting sibling or other relation that would be otherwise illegal. And the California Court of Appeal held that no, there is no protected liberty interest that exists that would stand to block the state in the state's ability to prohibit sexual relations of the kind outlawed by this penal code provision in California, the state incest laws. And the quote we can see from the Court of Appeals is as follows: California's interests in protecting the integrity of the family unit and protecting against inbreeding are sufficiently important to justify Section 285's incest prohibition. Let's go now from incest to peeping Tom laws. And again, what we're going to look at is the California Penal Code, and that is specifically sections 647 of the Penal Code, subsections I and J. And it's a very standard peeping Tom law, what's known as the peeping Tom laws, dealing with the illegal peeping or looking into a private residence of someone else while loitering on that private property. And so subsection I makes it a crime to peek into the door or window of any inhabited structure while loitering on that private property. Now, what's important to note here is that the root of these laws are aimed at regulating and controlling this behavior by people who may sneak onto a property to peep through a window to see someone getting undressed or engaged in sexual behavior with this sexual undercurrent to the laws. But the laws don't only address the act of peeping to see something sexual. If you peep just for purposes of peeping and maybe no one's even in there, but you loiter and you go and do the prescribed conduct, you are actually in violation of these what are known as peeping Tom laws. The second provision, it really deals with criminal invasions of privacy. And this is subsection J of Penal Code section 647. And this is fundamentally California's criminal invasion of privacy law. And this law prohibits three related but also distinct crimes. The first, as you see here on our slide, using a device such as a telescope or binoculars to invade a person's privacy. That's a crime. Second, secretly photographing or recording a person's body under or through his or her clothing for the purpose of sexual arousal or gratification. That's a crime also. And that one you can see has a very tethered relationship between the act of recording and the sexual gratification component. And finally, secretly recording or photographing another person in a private room in order to view that person's body or undergarments, also a crime. Now, on our next slide, we can see that these criminal invasion of privacy laws that exist to regulate human sexual behavior in terms of these behaviors of people who may go out and engage in these privacy invasions of others are very important and unique in this modern technology age that we're in. We have cell phones and we have drones, and these devices can record very, very easily from great distances on a whim because they have cameras attached to them and everything. And the behavior of people is such that everything is being recorded at a much greater degree in the 21st century than it was in prior centuries because of the ease of access to technology and technology that allows very, very cheap recording without great expense. And so what's very important to note here is that these laws engraft onto the use, for example, of drones. And so if you take a drone up out of your backyard and you attach your camera to it because you want to film and see what your house looks like from above, and then you start flying around the neighborhood and zooming, across someone's backyard, and you're recording into their house as you zoom by, your use of that drone that you think is completely innocuous because you're just filming, you actually now have tripped a wire and you're engaged in potentially the criminal invasion of privacy. And so this is very, very important to be aware of because of the modern use of technology that all of one's children are just using drones and cameras like nothing. These are things to educate our clients or our children or at cocktail parties when you're answering those questions, but to make aware those who are involved in the use of these technologies of the important nature of being careful so that you don't trip these laws aimed at regulating improper human sexual behavior. Basic advice, if you're sending up a drone in the neighborhood, don't record. Safest thing. Now, since we're on the topic of recording, let's go to the next slide. And on this next slide, you can see we're going to shift into obscenity law. And what this at root gets at is the viewing or filming of sexual behavior and sex acts in movies and what are known as porn movies, obviously, colloquially. And this is where obscenity law and the history of the regulation of obscenity by the state and federal level has interfaced with in terms of the legal regime, it's interfaced specifically with and primarily with those types of media, the filming and the making of adult content movies. And so we're going to look a little bit at the history of the regulation of obscenity and how the First Amendment interplays with obscene materials and the regulation. So if we go back to the 1950s, we're going to look at Roth v. United States. And Roth was a case that held in the early 1950s that obscenity is not protected by the First Amendment. And so here you can see the quote, which says, "Obscene material is material which deals with sex in a manner appealing to the prurient interest." Now, that was a somewhat narrow definition, and really what that meant was that the sort of the scope of the amount of content that could be created, which would be deemed obscene, suddenly got narrower than it had under pre-existing law. And that narrow definition of obscenity, which then made a whole bunch of other material now non-obscene and hence lawful, really opened the doors to much modern pornography and enabled the market to sort of flourish and grow for these protectable works of expression that then get regulated by copyright law to really explode. And so what we're going to look at a little bit here as we do this fun walk down the history of obscenity is take a peek at the Supreme Court and the Supreme Court's history with it. And so that Roth case, as I mentioned, was in the early 1950s. And as you see on the next slide, by the time we get to the 1960s, it had become a very fascinating area of law. And we have the famed aphorism, which I'm sure you all know from Justice Potter Stewart, "I know it when I see it." And that statement of his came from an opinion he wrote, a concurring opinion in the case of Jacobellis versus Ohio. This is a 1964 decision, and Justice Stewart concurred. And the case revolved around a movie theater owner who was arrested and then convicted under state law for showing obscene material. And the material he had shown was this French film called The Lovers. And The Lovers had a sex scene in it. And the local police came, they arrested him, prosecuted under obscenity statutes, and he's convicted. And his case goes up to the Supreme Court. The Supreme Court gets it, and the Supreme Court reverses. And the famous lasting line from the case is Justice Potter Stewart's quote that you see here, quote, "But I know it when I see it, and the motion picture involved in this case is not that." And that was his conclusion about how we draw this line between illegal obscene material and legal lawful non-obscene material when all of that material on that spectrum revolves around human sexual behavior being filmed on film. Now, by the early 1960s, what we have is a situational definition, ultimately, of trying to figure out obscenity. And his statement, "I know it when I see it," although it was a concurrence, really aptly captured what was going on at the Supreme Court and in the federal courts at this time as they grappled with all these cases coming up from all these obscenity prosecutions and trying to figure out whether a given movie was obscene or not. And it, at root, boiled down to, "I know it when I see it" at some level. And so it's a fascinating look at how the legal system grappled with and struggled with dealing with the regulation of adult content on a near case-by-case assessment. And so for that, we are going to take a look at the book, The Brethren. And this is Bob Woodward's seminal work. It's a spellbinding, masterful account of the Supreme Court in the late 1960s as it transitions from the Warren era to the now Burger era with the appointment of Chief Justice Burger to the Supreme Court by President Nixon. And in it is this fantastic story about the Supreme Court and its struggle with obscenity. And so it details in there what was known as Movie Day at the Supreme Court. And this is an event where the justices would watch the movies, literally, to try to assess whether they were obscene. And what's fascinating in terms of Bob Woodward's work is that he had ultimately, here is just an example of 3 different justices in terms of what they had concluded was obscene and not obscene. And so you can see Justice White, and these are quotes not from the justices, but from the book in terms of his research and discussions with law clerks and whatnot about the subject. But the quote for Justice White at least, in terms of what was ascribed to him in terms of his thinking about obscenity, is as follows: "No erect penises, no intercourse, no oral or anal sodomy. For Justice White, no erections and no insertions equaled no obscenity." Now, Justice Brennan was somewhat similar, but a little different. Justice Brennan was understood to believe as follows, quote, "No erections. He was willing to accept penetration as long as the pictures passed what his clerks referred to as the limp DICK standard. Oral sex was tolerable if there was no erection." Now, Justice Stewart, who I just told you had the I know it when I see it test, had what was referred to in this book as the Casablanca test. And that's the I know it when I see it. But it's referred to as the Casablanca test because Justice Stewart, during World War II, had been stationed as a Navy lieutenant off the coast of Morocco. And while there on his ship, he saw the men on the ship bringing back locally produced, Moroccan-produced pornography. And so he had had exposure to that on this ship, and so as he had said allegedly, or apparently, he was well aware of the difference between the hardest of hardcore pornography and just regular hardcore pornography. And so he knew where that line was, and he knew it when he saw it. And so that's actually a pretty fascinating account. Now, what's so incredible to assess and really consider here is how our legal regime regulates this behavior. And the Brethren book gives some really great insight into the law's struggle with regulating this area of sexual behavior. And so what I want to do is turn to a specific short part of this book, and I'm going to read it to you, and you can follow along on the screen with a photograph of a couple pages out of this book. But I want to turn to this discussion in the book so you can see exactly what was going on. And it really is the most remarkable stuff, that just unbelievable stuff to read. It's sort of spellbinding, like I said. And so to set the stage, Justice Marshall is at lunch with his law clerks. And so here's what it says. At Trader Vic's, Marshall had just launched into another story when he suddenly stopped. He stared at his watch a moment. It was about 1:50. "My God, I almost forgot," he said in a stricken tone. "It's movie day. We have to get back." Now, movie day was the humorous high point of most terms. Year after year, several of the justices and most of the clerks went either into a basement storeroom or to one of the larger conference rooms to watch feature films that were exhibits in obscenity cases that had been appealed to the court. Now, as it goes on here, Douglas and Justice Black never went to view any of those. They believed that the Supreme Court should not be a board of censors. But as the book goes on, you can see Chief Justice Berger preferred not to go. But the others sat on folding chairs with their clerks, watching such films as I Am Curious, projected onto a white wall. During his later years, Justice Harlan watched the films from the first row, a few feet from the screen, able only to make out the general outlines. He was going blind and didn't have great eyesight. His clerk or another justice would describe the action. "By Jove," Harlan would exclaim, "extraordinary." Clerks frequently mocked Stewart's approach to obscenity, calling out in the darkened room, that's it, I know it when I see it." Unbelievable stuff here in the Brethren, and that's an insight into what was going on in the court. But there's more that's actually very fascinating here to see how these justices are struggling with what can count and what cannot count. And so as it goes on, you have Bob Woodward writing, "Now the lights were about to go off as Marshall and White's clerks plunged through the door to see Vixen, a softcore feature film with nudity but no explicit intercourse. Marshall turned when the lights came on, as the projectionist was changing the reels, and said, 'Well, Harry,' referring to Justice Blackmun, Harry Blackmun, 'I didn't learn anything. How about you?' Blushing, Blackmun joined the rest of the room in a hearty laugh." Back in chambers, this is what's particularly interesting. Powell's clerks remarked to him that Vixen was disappointing. They were aware of it. Powell's gaunt face was expressionless. He had never before seen such a film, he explained slowly. He had had no idea such movies were even made. He was shocked and disgusted. He did not wish to discuss it further. Powell's clerks were amazed. There could not have been a milder movie for him to have seen. There had been nothing more than nudity and facial and bodily expressions that suggested orgasm. How would he have reacted to the hardcore peep show reels with nothing but explicit sex from beginning to end? That's a fantastic little portion of the book to snip it and read, because it really does show us how difficult it is for the legal system when it's struggling with the definition of obscenity to regulate obscenity in a way that works. And when it boils down to, I know it when I see it, and 9 elderly men watching movies to decide what's lawful and not, you start feeling that the law is getting a little situational and too case by case. And so that's it for obscenity in the 1960s. And on the next slide, you can see we get to obscenity in the 1970s. So you can see we're now at 1973 with the famed Miller versus California case. And this was a case where the US Supreme Court put some more structure into the legal framework and created this multifactorial test that ultimately brought an end to movie night at the Supreme Court and the need to have the Supreme Court sit down and review so many adult content movies. And so the Miller test, as it's known, and it's still known today, posits as follows. Whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest, that of course is dating back to that Roth case, whether the work depicts or describes in a patently offensive way sexual conduct or excretory functions specifically defined by applicable state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. The result was that much pornography that was being tested became, as a matter of law, not obscene, and it didn't require as much court intervention. But the important point here is that the contemporary community standards would vary based upon jurisdiction. So now if we fast forward from the end of, from the 1970s to the 21st century and we take a look at current law, the current basic legal standard is as follows. In light of the Miller test, obscene material may be regulated in terms of criminal law relating to distribution and public display of obscenity. But private possession of obscenity is actually protected. Now that doesn't include child pornography, but other non-child pornography obscene material, there is the right to possess it privately even though one is not allowed to publicly distribute or publicly display it. And that's the Stanley versus Georgia case from the US Supreme Court at 394 US 557 in 1969. And that case involved the facts as follows. A warrant was issued to go into a house to search a guy's house, and it was related to financial crimes, actually, bookmaking and the like in terms of those types of state crimes. A whole bunch of 8mm movies were found. The police, started looking at them and thought, aha, this stuff's obscene. He got arrested for obscenity. The material was deemed obscene. He was then convicted under state law for possession of, obscenity. This went up to the U.S. Supreme Court, which reversed. And the lasting quote from the U.S. Supreme Court in an opinion written by Justice Marshall is as follows, quote, "If the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch," end quote. And so the First and 14th Amendments and the right of privacy fundamentally prohibit the criminalization of private possession of obscene material. As we fast forward then to the 21st century, it's really very rare to have prosecutions for obscenity anymore, but they do occur for sex films where there is significant violence or other deeply odd sexual behaviors relating, for example, to the excretory functions and the like, as alluded to in that case, and or, of course, child pornography, child sex. There's a massive open question, though, in obscenity law and the modern law in terms of how it regulates human sexual behavior, and that relates to whether pure literary works can actually be obscene. And a fascinating case from 2007 is known as the Red Rose case, and this was a website where an author wrote fictional child molestation writings. And so these were these fictional stories talking fantasies about child molestation and the like, and writing about the act of molesting children. And so the person was indicted in Pittsburgh in 2007 and was prosecuted. And there was a legal challenge made to the prosecution, and the argument was that purely fictional works, without pictures and graphics and photographs and the like, but just a pure writing, cannot be obscene as a matter of law. The First Amendment must allow that material to be per se off limits to state regulation. But under the current law, the district court said no, it can be regulated. And what that meant is that the indictment in federal court for possession and distribution of child pornography materials and obscene materials was not dismissed, and the case would then go forward to trial. Now the case ultimately settled, and the author was given 5 years probation for this behavior. And so as it stands today, we have this open question because no case has percolated up to the US Supreme Court to really address whether state criminal laws can outlaw purely fictional obscenity writings or whether the First Amendment actually allows such writings to be protected. From obscenity and sex films in the last 50 years, we're going to shift from that area of law, First Amendment obscenity law, to another aspect of First Amendment law, but this deals with trademarks and the regulation of trademarks and the interface with the First Amendment in this space we're in terms of sexual expressive conduct or sexually expressive marks. And so the historical rule when it comes to trademarks is that immoral or scandalous marks cannot be registered as trademarks. And so you have here sort of the prototypical law, old historical rule that existed, which is to be considered scandalous, a mark must be shocking to the sense of truth, decency, or propriety, disgraceful, offensive, disreputable in the context of the marketplace as applied to goods or services. Scandalous is determined from the standpoint of not necessarily a majority, but a substantial composite of the general public, and in the context of contemporary attitudes. And that comes from a Federal Circuit case 33F 3rd at 1371. You have the trademark prosecution manual in terms of setting the rules for trademark prosecutors and for the trademark government examiners, indicating that evidence that a mark is vulgar can show that it's scandalous or immoral, and dictionary evidence alone can be enough to show that a term is vulgar if multiple dictionaries uniformly indicate that the meaning is vulgar. And so as we go to the next slide, what you can see is the result of that set of rules was that there were no trademarks on sex-related marks. And so no FUCKS given for t-shirts, hats, or clothes, that was the trademark, was denied because it was too sexual. FUCKU was someone sought to get the mark on those two words for alcoholic beverages. It was rejected and the person never continued to pursue the mark. And so the standard quote you can see again is that the fact that profane words may be uttered more freely in contemporary American society than in the past does not render the words any less profane. And so the result here is, at common law at least, and over the last 50 to 100 years of federal trademark law, sex-related marks, words that had a sexual connotation, such as those examples on the slide, were simply not given federal registration or trademark protection. But that changed late 2017. And so the next slide, you can see the case in the Federal Circuit called In Re Brunetti. And this was from the Federal Circuit, December 15th, 2017, a published opinion, and there was a clothing line called Fucked, spelled F-U-C-T. And the person had sought a trademark registration, but was denied because the word was the past tense of the commonly and colloquially used other F word. And so a scandalousness, immoral analysis was applied to that, and that is why the mark was rejected. But the Federal Circuit found, in light of recent Supreme Court opinions dealing in a different context with the permission of marks that would otherwise not be allowed in light of the First Amendment, the court ultimately held that the First Amendment does not allow the government to deny issuance of a federal trademark registration based upon the content of the mark. And so this is the case even though we're dealing with commercial speech, which is subjected, as you know from constitutional law, to less than strict scrutiny, to a more intermediate scrutiny standard. But the court held it still failed intermediate scrutiny because the mark was lawful, it wasn't misleading speech, the government doesn't possess an interest in promoting certain trademarks over others, and the government's interest in not having people offended or in people not hearing profanities is simply not strong enough to justify denial of the registrations. And that opinion is standard now black letter law in this area in terms of trademark registrations. And it picked up on a big Supreme Court decision from 2017 where a trademark by the band known as the Slants had sought trademark on the word slants, which was denied by the trademark office because it was deemed racially offensive to Asian Americans. And it went up to the Supreme Court, and the band, in an act of reappropriation of what had historically been a derogatory term, but this was sort of this cultural reappropriation by the band, the Supreme Court said no, they have an absolute First Amendment right to not be denied access to a federal trademark registration. And that holding in theory of the First Amendment ports over to sex law and trademarks in the sex space. And so that takes care of the current state of the law in terms of trademarks and the regulation of sexual behavior. And so what this means for you is if you practice in the intellectual property area, or if you have clients that have historically been involved in making products that may have a sexual term or tagline in them, which they had never been able to get a trademark on before, or which they never thought they could. Those clients now have a whole new world that's opened up to them in terms of brands and brand recognition. Or you may have clients that want to start a new business, and these are now areas where the metes and bounds of this monopoly right in a trademark can be set down and laid down by your clients if they want to go and take something that was historically not allowed but now is allowed, some sexual term or phrase, and build a brand and a business around it. That is now possible in terms of the new modern world of sex law that we're in. But we're going to shift now from trademarks to prostitution, because the world is not so new there. Prostitution is criminalized at the federal and all state levels, and criminal laws attach both to the prostitute and to the customer, as well as pimps or brothel owners for pandering and for creating it. Now, I said it's criminalized at the federal level. This is where it's criminalized at the federal level, for example, and here are some examples. If an alien seeking admission to the United States has committed any prostitution within 10 years, then that alien is not admissible as a matter of law. There's no exception under this law, even if the prostitution was legal in the alien's country of origin. No exception for it. So if someone wants to seek immigration admission to the U.S. and they've been involved in prostitution in any way in the prior 10 years, they're per se excluded. By the same token, there's a provision that if someone engages in prostitution within a reasonable distance of a federal military base, then they get up to 1 year in federal prison for those acts of prostitution near a federal military base. We'll shift to the next slide now and start looking at some state examples. And we'll take California, Penal Code 266 and 647, which outlaws prostitution and pandering and pimping. And this gets us into the heart of what is prostitution. Well, Section 647 states that prostitution includes any lewd act between persons for money or other consideration. Now, what's a lewd act, of course, is the million-dollar question. This has worked its way up to the California Supreme Court on many occasions, you'll find in the case law, but the seminal case really is People v. Freeman in 1988, and you see the quote here. The genitals, buttocks, or female breast of either the prostitute or the customer must come in contact with some part of the body of the other for the purpose of sexual arousal or gratification of the customer or of the prostitute. That's the definition of lewd under current law. And so then the issue in many cases then, of course, is what amount of sexual conduct or contact between people actually triggers and falls into the category of lewdness such that one can be prosecuted for prostitution. How much physical touching is required? Is any physical touching required to be arrested for prostitution? That has been answered by a strip club case, of course. This is known as the Flesh Club case. And this addresses what's lewd and does there have to be actual physical contact between customer and dancer. This case, the Flesh Club case, is known as Wooten versus Superior Court, 93 Calap 4th, 422, and it's from 2001. The Flesh Club was sort of a strip club, and it had a stage with nude dancers, and then around the stage were chairs and couches where the customers or patrons could get lap dances. Now, there was this, what was known as a VIP room that had several booths inside this sort of room, and each booth was covered by a sheer curtain of sorts, the opinion describes, to sort of let there be privacy in the booth between customer and dancer. And so some undercover police posed as customers, and they got back to one of these booths with two female strippers. And the undercover officers convinced the two strippers to perform sex acts on each other, but not on the undercover officer or the customer. And so the two women were given money, they performed sex acts on each other, touching each other's genitals and the like, but they never touched the undercover officers. The police then sprang out of their customer disguise into sort of their I'm a police officer, arrested everyone, including the club owners, and everyone was charged with prostitution and pimping and pandering and the like under 647. This then goes to the California Court of Appeal, and the California Court of Appeal said no. And this is what happened. The customer's observation of sexual conduct between two dancers, even if for consideration and money, does not constitute a lewd act for purposes of the anti-prostitution laws because bodily contact between prostitute and customer for sexual gratification is required. Quote, as objectionable as the performances are in this case, we are loath to find a public policy requirement that the acts be criminalized under existing law. That was from page 437. And so what that has made clear is that paying two people, two dancers, for example, at a club, to touch each other but not the customer doesn't count as prostitution. There needs to be this physical contact between dancer and customer for sexual gratification and an exchange of money in order to potentially trigger these anti-prostitution laws. The People versus Freeman case on the next slide gets us to what is the line between pornography and prostitution? And it's a question that's been asked many times because in pornography, which is protected speech as we saw when we discussed obscenity, actors are paid to engage in sex with each other and it's filmed and watched and whatnot. And people have posited the question, why isn't that just like private prostitution going on? And this case of People v. Freeman addresses that line between pornography and prostitution. In People v. Freeman, an adult film producer, Mr. Freeman, was charged under California state pimp and procurement laws because he paid 5 women to act in pornographic films that he produced. These were not obscene pornographic films, they're just your prototypical pornographic movies. He's then indicted and convicted. This goes up to the California Supreme Court, and the California Supreme Court says that no, the anti-pimping, pandering, prostitution laws are not intended to apply to adult movies where the person is being paid to act in a movie, and hence they are all engaged in protected expression under the First Amendment. And so the payment of monies was for acting, not for the sexual arousal or gratification of the payor, the porno movie producer, or the payee, the actors in the film. And so, and on top of that, the defendant Freeman didn't participate in any of the conduct anyway. And so this is what the California Supreme Court held. Even if the defendant's conduct, quote, could somehow be found to come within the definition of prostitution literally, the application of the pandering statute to the hiring of actors to perform in the production of non-obscene motion pictures would impinge unconstitutionally upon First Amendment values. And so that gets you to the line between pornography and prostitution in terms of pornography, if it's not obscene, not being subjected to the anti-prostitution legal regimes in all the states. Now, I say the anti-prostitution legal regimes. That gets us to the next slide, which is legalized prostitution. It does exist in a few rare places in the United States, one of which is a particular county in Nevada, where this county has permitted prostitution subject to very strict legal requirements. And so you have down there at the bottom of this slide the actual website you can go to where you can get the very strict set of legal regimes, but I'm going to give you an overview here because it's a fascinating document to read if you want to go into this sort of arcane world of sex law and see how when prostitution is allowed in a given jurisdiction, how is it regulated? What are the structures put in place? And so here are some highlights from Churchill County, Nevada, and this is the regulatory regime overview. Number 1, only female prostitutes are allowed. They must be over the age of 21, and all patrons must be over the age of 21 also. A license is then issued for a house of prostitution only. There are no outcalls. All of this must be done in a defined and specific physical location, literally like a house or a building. But the prostitutes in this legalized arena are not allowed to leave the facility and go engage in prostitution somewhere else. Everything has to be done within this licensed facility. Now, number 3, the police have the right of access at any time, no matter what, without a warrant. They can just come in and do whatever search they want to ensure all compliance with this entire regulatory regime and licensing, and whatnot. So there's this massive waiver in effect of what would otherwise be Fourth Amendment rights against warrantless searches and seizures. Owners of these establishments are subject to super detailed background checks into sort of every nook and cranny of their life. It's fascinating when you read the document. Now, this is what particularly interesting too. Number 5, no male employees are allowed to work in these prostitution houses unless they're a bartender or they're providing sort of maintenance to the building or repair type or managerial type services in that very narrow capacity. But basically, everyone in the place has to be a female employee. There must be full fingerprints of all employees given, and there are weekly medical examinations required of all prostitutes with weekly STD tests and then monthly HIV tests. And then finally, mandatory latex or condom usage is required. And so it's a fascinating, the website's there, you can go read the document. It really is a fascinating look at how our legal regime, when we flip on these very rare instances from outlawing prostitution to allowing prostitution, how structured and complicated and detailed it is in terms of the legal oversight. This gets us, on the next slide, back to pornography and the act of filming sex acts, and we're going to look now at some federal criminal laws and then the federal copyright laws that are regulating this human sexual behavior. Generally, of course, it's protected within the First Amendment to make adult content movies, but there are very, very specific and stringent federal criminal laws that attach to those who film and make and produce and distribute adult content. And these are known as the 2257 laws that deal with the labeling of the adult content and the regulations that require that those who produce and create and distribute adult content must maintain documents verifying and proving the age of the actors to make sure they're all of appropriate age so that there's no child pornography. And then those documents must be kept by the producers, and there's this labeling requirement where material has to be labeled into the actual film indicating compliance with the law. This, of course, in the 21st century with the internet and tube sites, what are commonly known as tube sites like YouTube for regular movies, there's YouPorn for pornography movies, where these sites have thousands of films uploaded by users, and then anyone can go and watch for free adult content. This, of course, triggers all sorts of legal complexity, and we get to the next slide, which is dealing with the criminal complexity, and a big case coming out of the Ninth Circuit, Ventura versus Motherless. And I will tell you now as a disclaimer, I was the litigator in the appellate court for Ventura Content, an adult content company that sued one of these tube sites. And so one of the issues pressed in this appeal that went up to a big published opinion in the Ninth Circuit in 2018 was that the criminal labeling laws that apply to producers of pornography should apply to those who retransmit the pornography, such as the tube sites, so that if they want to take offerings from users of adult content and then redistribute it, they should also have to comply with the labeling laws. And if they can't, then they're in breach of these criminal laws, and so their tube site should be shut down. That argument was rejected by the Ninth Circuit in the opinion in this Ventura versus Motherless case. It's subject to a rehearing petition, but as it currently stands, those criminal laws do not apply to the tube sites that distribute and disseminate adult content as uploaded by users. The next slide gets to a bit more on the copyright side of this, and that is those tube sites have immunity under the Digital Millennium Copyright Act in terms of copyright infringement liability vis-a-vis the content owners, such as my client in that example, Ventura Content. And so this DMC safe harbor allows companies to be immune from any copyright claims. And so there are a plethora of challenges that one can make. The root of the challenge is that the tube site operator has red flag knowledge and is perfectly aware of the fact that all the content being uploaded is actually content that is owned, is professional content owned by others, and this sort of knowledge and awareness should take away the immunity. The Ninth Circuit rejected that argument too. It's subject of a rehearing petition, so stay tuned for Sex Law 2, and we'll let you know if the copyright world has changed at all. Now, as we move from copyright and all these areas, we're going to shift to the question of adultery. And on the next slide you can see the question we raise with respect to adultery is, how does the law regulate adultery? Is adultery illegal? Can it be illegal? The answer is yes. As of 2017, adultery remains a criminal offense in 21 different states. And in 2 of them, it's actually a felony, so it's not just a misdemeanor. Now, over the last several decades, there were more states that had criminalized adulterous behavior, but many states have repealed their adultery laws. But nonetheless, in 21 states, adultery is still illegal and it's on the books. And so what I have here are some quotes of some prototypical states that we can look at. Utah, Criminal Code 76-7-103 states, a married person commits adultery when he voluntarily has sexual intercourse with a person other than his spouse. Adultery is a Class B misdemeanor. Massachusetts similarly outlaws adultery, and it provides that a married person who has sexual intercourse with a person not his spouse, or an unmarried person who has sexual intercourse with a married person, shall be guilty of adultery and shall be punished by imprisonment in the state prison for not more than 3 years, or in jail for not more than 2, or by a fine of not more than $500. And finally, you can look at Maryland. Maryland's I thought was quite interesting because it says, it's very, very short and simple. It says, a person may not commit adultery. A person who violates this section is guilty of a misdemeanor and shall be fined $10. I'm guessing that statute is old, but it's still on the books with a $10 fine if one engages in adultery. The question, of course, this gets at in the modern age, the modern world, where there has been much litigation over human sexual behavior and the protected liberty interest in one's private sexual behavior is there a constitutional right to engage in adultery? And so on the next slide you can see that challenges have been made to the anti-adultery laws, positing that one possesses a privacy right to engage in extramarital sexual relations, but that has been rejected by the courts. And a prototypical decision is this one from Utah. It's Oliverson versus West Valley City. It's reported 875 F. Sup. 1465 from the federal court in Utah in the mid-1990s. And the court found that the adultery laws survive, or the anti-adultery laws, survived rational basis review because the state has an interest in protecting the family unit and the integrity of the family unit and in preventing disease, and those interests alone were enough to allow the state to criminally punish one who engaged in adultery. Now, what's fascinating is that's not that long ago. We go back a little over 20 years to the mid-1990s, but of course, in the last 10, 15 years, there have been massive constitutional challenges raised about anti-same-sex marriage laws, anti-sodomy laws, all of which laws have fallen in light of the Supreme Court's pronouncements relating to one's liberty interest, one's constitutionally protected liberty interest, for example, in same-sex relations or in the anti-sodomy laws that have been struck down, and then the right to marry. And the breadth of the case law actually is pretty broad. And so it does make one wonder if in the future we will have some challenges to these anti-adultery laws, and if in light of the Supreme Court's more recent pronouncements about the nature of the liberty interest, one's personal private liberty interest in sexual activity and behavior, if these anti-adultery laws will survive constitutional challenge or if they will still stand as they have thus far. That also waits for Sex Law Part 2. Next, we're going to get to bestiality, and it's illegal in 45 states as of 2017. And I know you're saying, only 45? Why not everywhere? The reason actually is interesting. Some jurisdictions used to have laws making it illegal to engage in bestiality, sort of sexual relations with animals. But as many of these jurisdictions struck down their anti-sodomy laws, they struck down other laws with them too. And in some places, then the anti-bestiality laws got repealed along with the anti-sodomy laws. The District of Columbia is one example. Now, other jurisdictions actually never expressly criminalized the behavior, although it certainly could fall within animal cruelty laws that are on the books of those jurisdictions. But these other jurisdictions that haven't outlawed it expressly, these 5, many of them actually have bills literally as of early 2018 pending to pass through the state legislatures to outlaw sexual abuse of animals. And a perfect example is this one from Hawaii. It's Hawaii Senate Bill 2289, and I just quoted for you here the first section, that says, the legislature finds that 45 states have laws prohibiting animal sexual abuse, which is also termed bestiality. Animal sexual abuse is a sexual molestation of an animal by a human. While Hawaii has effective animal cruelty laws, animal sexual abuse is not adequately addressed because the cruelty laws require proof of specific actions such as torture and other actions that cause bodily injury or death to the animal. Many acts of animal sexual abuse are discovered after the incident occurs and the requisite evidence cannot be obtained. And so states are now joining on the forefront to deal with laws to be enacted to protect animals and to outlaw that form of human sexual behavior. Now we get to the conclusion. the fun part. Crazy, weird sex laws that are on the books of different states. These are all true. The first one you can see. This is a local ordinance and code from Walnut, California. I last checked it in April of 2018, and it's still on the books for Walnut. And in Walnut, you need the sheriff's permission if you're a man and you want to dress up as a woman. And here's a quote of the law. It's true. No man or boy shall dress as a girl or woman without a permit from the sheriff, except for the purpose of amusement, show, or drama. You can't make this stuff up. That's an actual law. So let's go to the next crazy, weird sex laws, and this one involves public restraint. Florida. Married couples in Florida cannot engage in openly lewd or lascivious behavior. And this is a Florida criminal statute, 798.02, that says, if any man or woman, married or unmarried, engages in open and gross lewdness and lascivious behavior, they shall be guilty of a misdemeanor of the second degree. Now, there have been no recent prosecutions that I could find in the last half of the 20th century under this in terms of married people. But by the same token, we all see the pictures of what goes on South Beach on spring break. So married people, you may want to be careful if you're in Florida and you get carried away after a few too many drinks in public, being too close and huggy and the like. Let's move on to the next crazy, weird sex laws. This is in Alabama, where it's a crime to sell a dildo. And so in Alabama, the law says, it shall be unlawful for any person to knowingly distribute, possess with intent to distribute, or offer to distribute any obscene material or any device designed or marketed as useful primarily for the stimulation of human genital organs for anything of pecuniary value. So if you're in Alabama, you don't want to be selling those types of sex toy products. But on the next slide, you can see it gets a little crazier. Because if you're in Texas and you happen to even own more than 6 of them, you can go to jail. Yes, it's true. Texas makes it illegal to have more than 6 of these sexual devices. And there's the Texas Penal Code, which states a person who possesses 6 or more obscene devices or identical or similar obscene articles is presumed to possess them with the intent to promote the distribution, the sale of them ultimately. And you can see there the Texas appellate court opinion, which held that a vibrator is indeed an obscene device within the context of this law. So, don't own more than 6 if you want to be safe in Texas. Now, let's go to Nebraska on the next one. Nebraska, you got to be clean to get married. In Nebraska, it's illegal to marry if someone has a sexually transmitted disease. Here's Nebraska Revised Statute 42-102. At the time of the marriage, the male must be of the age of 17 years or upward, and the female of the age of 17 years or upward. No person who is afflicted with a venereal disease shall marry in this state. That's on the books in Nebraska, and it's still the law. And let's go to the last crazy, weird sex law. This one is mind-blowing on so many levels. It's effectively state-mandated shotgun weddings almost. It comes from South Carolina, and basically the law is if a man seduces a woman into bed by promising marriage in order to sleep with her, and then reneges on the promise, it's a crime, and you can go to jail unless he fulfills the promise and suddenly comes back and says, fine, I'll marry you. It's all true. Here's the Code of Laws of South Carolina. The title is Seduction Under Promise of Marriage, and it's filled with so many stunning statements, it's hard to believe. A male over the age of 16 who by means of deception and promises of marriage seduces an unmarried woman in this state is guilty of a misdemeanor and upon conviction must be fined at the discretion of the court or imprisoned not more than 1 year. Now, first of all, it doesn't apply to women who may deceive men into marriage. It's only focused on men doing this to women. But then the statute goes further. It says, there, however, must not be a conviction under this section on the uncorroborated testimony of the woman upon whom the seduction is charged. If 2 people are alone and one is seduced under this statute, she can't come forward and make a claim because it's uncorroborated. A remarkable statement given the whole premise of the statute in terms of what it's doing. And then even more so, no conviction at trial if it's proven that the woman at the time of the alleged offense was lewd and unchaste. So the woman now is put on trial for being lewd or unchaste herself in order for the man to get away with the false promise of marriage. Unbelievable in the 21st century to see it. And then the shotgun wedding part is the final sentence. If the defendant in any action brought under this section contracts marriage with a woman either before or after the conviction, boom, you get out of jail free card and everything stayed and you're okay. Seduction under promise of marriage. Crazy weird sex law. And that's it for our crazy weird sex laws. If you have or know of any in your jurisdiction, please email me and I'll add them to Sex Law 2 of the Curious Lawyer series. And in the final slide, of course, the advice for all of you and for our clients who may be traveling for court, for depositions, for negotiations, the most fundamental advice when you're thinking about sex law and the different states' regulation of sexual behavior, whether it's sexual behavior you're engaging in or watching or filming or whatnot, the best advice is don't ever assume that the regulatory environment that you're used to or familiar with, i.e. where you live, will remotely apply where you're going. All bets are off. And given this CLE, be very, very careful. That's the line. Thank you very much, and that brings to a conclusion this episode of The Curious Lawyer.